Good afternoon, my name's Debbie Ross from Chichester College, and today we're going to be discussing the Certificate in Understanding Data Protection and Data Security, which is a VRQ. So today we're going to be discussing how you enrol on the course, the information around the delivery for the NVQ. We'll have a presentation by Ben Phillips, who is the Chichester College ambassador really for the VRQ in data protection, and he's our data protection officer here at the college. Okay, so the objectives of the webinar are to discuss the expectations of the VRQ, what we expect from you, the benefits of studying this qualification, recognising the different components, and how to complete the enrolment process. So in the enrolment forms we will email out to you after the webinar if you're interested in taking up the course, and we do need those to be completed and emailed back to Kim Lewis as it says on there. From there you'll be assigned an assessor who will contact you within 7 days and send you the first 3 questions that we ask you to complete. The induction, after that you'll have the 12-week programme. You may be able to do it quicker than that. I did it myself over a weekend, and I know Ben did it in a relatively short period of time as well. But we don't expect you to do it in that time. You are given 12 weeks, so it may be that you take longer to complete. So the resources are the learning packs, which I'll go through in a minute. You'll get booklets to help you answer your questions and write up, but you will be expected to do your answers on what's called e-assessor, and we will talk you through that once you've been assigned your assessor. The feedback can take 2 weeks. You have to allow the assessor to mark your questions, and we'll go through that again in a minute for you. So we have 2 workbooks in the data protection qualification. So what you will have is examples. So it starts off by saying, please read the following as it will help you answer question 1. So that information will help you answer question 1. Then it will go on to say, please read the following, it will help you answer question 2. So you've got the information you need on part 1 and part 2 to answer those questions. There will also be parts in the booklets that say, did you know? And it will be a sort of a bubble that will say, this is information about the qualification. This is a relevant part. And Ben will expand on that more later on. But it just helps you within the booklet to answer those questions. You'll also have a knowledge activity. So it may say, as it does here, knowledge activity 1, put a tick next to the scenarios that you think could use as legal obligations. These knowledge activities and this workbook is yours. These aren't marked by the assessor, so you can do those if you want to, but there's no obligation to do those, but it does enhance your learning, your knowledge and your skill. Okay, when you go through the booklets, it does ask you at the very beginning to answer your questions using the following: define, describe, explain and outline. So if you are defining something, that is a definition. So then you will be copying that directly from the text. But we like you to back that up with an example so that you're enhancing again your knowledge and your skill. Describe and explain are exactly as they say. They're in your own words and you're describing the information you've been given, as I mentioned in workbook 1, and you're describing that information. So using your own workplace experiences or experiences of other employers or personal interests or hobbies that you may have that are relevant to the question. For example, here it says, in my own organisation, we. This is how we would. An example of this is. We need you to type everything up on a Word document before uploading to the e-assessor, because this is a safeguard for yourselves, because in case your computer crashes or the work is lost, and then at least you've got a backup there. Equally, the e-assessor doesn't check your spelling or grammar. So again, we would like that, because we do mark, as assessors, we do mark you on the spelling and grammar. So you do need to ensure that that is all correct. Any attachments, they need to be emailed to your assessor directly, and please ensure that you have your date, the the question that it refers to, your name and your signature on it, so that we can prove that it's your work. We quite often get emails through, and if we're printing 3 or 4 things off at one time and it hasn't got that information on it, we're not sure whose it belongs to. We will give you feedback at the end of each workbook. So when you've completed on eAssessor the questions for the first assessment or the first workbook, we will give you feedback. We can't answer 3 or 4 questions at a time. If you do get stuck, then please do let us know, and we can, if you're stuck on question 5, for instance, just email me and say, I'm stuck on question 5, not sure what they mean by this, and I will give you help or feedback. But I won't be able to mark questions as I go along until you've completed the whole workbook on eAssessor. Also with the workbooks, we would expect you to reference these or any external work that you do and you're referring to. So if, for instance, you get some information from another source, we would like you to reference that. We don't need you to reference it all the time, but just where you're applying this. So at the beginning you could state that my questions have been sourced via the NCF workbook. Or it could be that you've done some research on Google and you found a relevant source, or it could be your company policy. So you could put, according to my company policy, or I am referencing as per the source that you found on Google. The ICO has a lot of information on there, and it may be that you want to reference that. Okay, so this goes through the different types of things that are expected from the different workbooks. So workbook 1 covers the knowledge to understand the differences between GDPR, data protection, and the Freedom of Information Act, what a DPIA is, and the role of the data protection officer. And again, Ben will go into more detail on some of these aspects when he does his presentation. So it also assists you with the understanding of what the legal requirements around GDPR and data protection are, the penalties, and how organisations can prevent security threats. So assessment 1, you need to provide work-related examples. I've said that already, and that is key to the answering the booklets. Workbook 2 covers the knowledge to understand threats to personal and workplace security, what the denial of service is, or DOS, different types of malicious software, how to protect your own personal information, regulations and consequences on protecting data. And assessment 2, again, is giving workplace examples. What we've covered today is the objectives for doing the VRQ, the different types of components in this GDPR or data protection, how to complete the enrolment process, and also progression routes. It could be that you want to be your employer's data protection officer, or you want to be the expert, the go-to person. But it's also useful in your personal life if you belong to clubs or external bodies, that you know what the data process is. Even if you only use it for your personal benefit when you have to tick in the box, or for emails, or you go to a shop and they ask you, do you want to opt in or opt out, you understand a little bit more about it. It's very important that most people now have had some sort of training or experience in data protection. It's also really good on your CV because it shows that you're willing to learn in your own time. Thank you very much. If you do have any questions and answers, then please obviously email me and I can follow those up or have a telephone conversation with you. Thank you very much.
Welcome to the second part of this webinar. My name is Ben Phillips and I am also part of Chichester College, working within the data protection team. I'm going to continue from where Debbie left off, and I'm going to talk you through some of the basics of GDPR and data protection to help you in the first steps of this workbook. I would also like to note that this information is general and can be applied to a number of organisations. But when considering what is right for your own organisation, you may need to seek additional advice from either a lawyer or a GDPR practitioner. So we're going to go through a number of topics during this part of the presentation. We're going to look at what data protection is and consider the differences between GDPR and the Data Protection Act and what that means in practice. We're also going to go through and consider what a controller is, a processor and a sub-processor, and try to understand what this terminology really means. We will also understand what rights you have under data protection legislation, and consider what you need to do as an organisation if you were to have a data breach. And then there'll be an opportunity for questions through your assessor at a later point should you have any. So, what is data protection? Data protection is about giving you as an individual control over who has your data. It's about protecting your privacy. It covers any information which can be considered your personal information. This could be anything from a name and address to your email address and various other contact details, your national insurance number, your medical history, and goes as far as online activity, what you put on your social media pages, where you log on, so your GPS data, and also your online buying behaviour, so things such as your Amazon shopping cart could be considered your personal data. We've had data protection legislation for a long time. The previous legislation was the Data Protection Act in 1998. So 20 years of legislation has existed, and the majority of what was in the previous legislation has been carried forward. However, there are some key differences, and these come in place in consideration of how technology has changed and how businesses are using data. A lot more happens online. We didn't have social media and email quite like we do back in 1998. Equally, business is on a global scale. Our ability to transfer data overseas is becoming quicker and easier than ever. This new legislation accounts for those changes and puts greater emphasis on businesses to be able to audit their processes and show their competence in understanding and complying with data protection legislation. So what is the difference between GDPR and Data Protection Act? They are both there to do the exact same thing. They are there to give you as an individual control over who has your data. The difference is GDPR is on a European scale and means that any member state of the European Union is using your data in the same way as any other state. What the Data Protection Act does is it gives some context for the UK. So, post-Brexit, Data Protection Act is in play, as it already is now. Data Protection Act also gives consideration to law enforcement, special forces. It considers what individual companies can do in their capacity as a local authority, and it also considers the wider UK legislation in deciding how data protection works. For the most part, the legislation, as it currently stands at the point of filming this, is one and the same. But the Data Protection Act should always be considered in your decision-making process in case there are any small changes to apply to UK legislation. So, what is a controller? In legislation, a controller determines the means and purpose of processing. And processing is anything that we do with personal data, from collecting to storing to deciding what we actually do with it while it's in our care, and to getting rid of that data when it is no longer required. So you are a controller if you are deciding the means and purpose. As a controller, you may involve a third party in your processing activities. If you do so, that third party is likely to be a processor. They are using the data you have provided as a controller, and they are acting on your clear instruction on how to use that data. They are no longer deciding the means and purpose. That remains yourself as a controller. And in some cases, you will also have a sub-processor. So this is where a third party is acting on behalf of the processor to manage the data of the controller. So you can have 3 tiers of control over this data. There will also be occasions where you have a joint controller, where both organisations own the data and decide means and purpose. This may be in different contexts, but applies to the same data set. It is important for you as an organisation to understand who has control over your data, as this will affect how it can be used and what legal responsibilities you have when it comes to reporting data breaches and managing data subject rights. Where a controller makes use of a processor and a processor makes use of a sub-processor, it is important for there to be a data sharing agreement in place to manage that process and make it clear who has what obligations. So let's look at some practical examples. In this example, we have a local store and they want to send out an e-newsletter to their customers. This store has collected the email addresses of its customers and it will be sending out the e-newsletter. Therefore, in this example, the controller is the local store and there are no sub-processors involved. The controller has collected the data, it is deciding how and who it will be used by, and they are carrying out those actions. They are solely responsible for the use of this data under data protection legislation. But in this second example, we have that same local store. They want to send out an e-newsletter, but they have employed the services of a marketing agency. In this example, the store are still supplying the customer details to the marketing agency, but the marketing agency is then sending out the newsletter. In this specific scenario, the data controller is that local store, and the marketing agency are a processor. It's important to note that depending on how clear those instructions are, and to what degree that marketing agency is deciding on how to use that data, would affect its position as a processor or controller. And that's why it's important for you to consider this when deciding how your customer data will be used going forwards. So let's look at rights. You as an individual, just as any other member within the European Union, has rights under data protection legislation, and you have 8 rights. These include the right to be informed. This is privacy notices, privacy policies. I am going to use your data in this way. I will keep it for this long. I will share it with these people. If you have a problem with this or have further questions, this is who you contact. That is your first right under data protection legislation. Your second right is the right to access. This is being told what information an organisation holds on you, and if they do have information, the ability to request that information and to have copies. It's important if you do provide information not to disclose other people's personal information, because that may be considered a data breach and have wider consequences for both the individual and your organisation. Your third right is the right to rectification. This means if information is wrong, please update it. Equally, if information is incomplete, please populate these fields. You have the right to know what information an organisation holds on you and ensure these are accurate. Right number 4 is the right to erasure. You already know what information an organisation holds on you because you've used your second right, but you no longer want them to hold that information. In certain circumstances, you can have that information deleted from their systems. Right number 5 is the right to restrict processing. You have the right to control how your data is used, and in certain circumstances you may be able to restrict that processing so it is only used in certain ways. Right number 6 is the right to data portability. Information that you have provided to an organisation, you have a right for that information to be moved to another organisation to provide a similar service on a different platform. A classic example is when you change bank accounts. You make use of the current account switch service, moving all your information from one bank to another bank, and you're doing so using your right to data portability under the Data Protection Act and GDPR. Right number 7 is the right to object. This, similar to the right to restrict processing, is telling an organisation not to use your data in that way. But in this scenario, you're objecting completely. When it comes to marketing, this is an absolute right, and is why it's important to have an unsubscribe option on any email or postal marketing or telecommunication marketing, so that people can remove that consent or that legitimate interest. Right number 8 is in relation to automated decision making and profiling. This is where a machine is making the decision based on data entered into its system as to whether you are eligible for a service or the outcome of a process. Under this right, you have the right for a human to consider the process and to re-evaluate what the machine has decided. These are your 8 rights under data protection legislation, which you are able to enforce, but equally as an organisation you must be able to comply with. The Information Commissioner's Office website has further details on these rights and how you as an organisation can comply. So now looking at data breaches. What is a data breach? It's either unlawful or accidental loss, destruction, alteration, disclosure, access to information. So we're going to look at data breaches by considering an example. In this example, an employee has lost a memory stick while on the train home from work. This memory stick contains client data. That in itself is a data breach and therefore needs to be recorded internally. But what is on that memory stick? The client details include contact information, but there's also information about protected characteristics and medical information. That in itself has increased the risk of that data and the potential consequences if it is got into the wrong hands. Therefore, you would start to consider whether this needs reporting externally. However, in this particular scenario, we also learn that this memory stick has been encrypted, meaning that the information cannot be accessed without the password. Assuming that you are the only one with that password, the overall risk level is reduced, and it will be up to you as an organisation to consider whether this still needs reporting externally. When looking at data breaches and our reporting obligations, we have to report all data breaches internally. And you, as an organisation, should maintain a central register of a data breach, when it occurred, when it happened, and what action you have taken as a result. You have an obligation to investigate all data breaches reported to you. And you have 72 hours from the point that you discover a breach to have made a decision whether or not it needs to be reported externally. And that external organisation would be the Information Commissioner's Office, also known as the ICO. They are there as a supervisory authority within the UK, and they are there to uphold the rights and freedoms of data subjects, i.e. your employees, your customers, your stakeholders, and everyone who has personal data in your care. It's a case of considering what is the risk, and if there is a risk to the rights and freedoms of the individual, then you have an obligation to report a data breach to the ICO. If you do have any questions following this presentation, then please contact your assessor, who will be able to assist you. Equally, if any of these items you are considering whether this has an impact on your organisation, likelihood it will, and you will already have steps and processes in place in order to comply with the legislation. It may be that you seek further training following this VRQ to strengthen your knowledge, or it may be your organisation needs to consider whether it employs or contracts in a data practitioner in order to assist it with its compliance with data protection legislation. This remains an important topic and will not go away, so by completing this VRQ, you are in the first steps to ensuring your compliance with data protection legislation and the compliance of your organisation going forwards. Thank you.